Ladies and gentlemen, before we continue with our conference, I would like to invite Mr. Rouby of the Fonds National de Recherche of Luxembourg, the Luxembourgish Research Fund, to give a short presentation about what the Fonds National de Recherche Luxembourgeois is doing for the academic institutions here in the Grand Duchy. And I must say we are very grateful that the Fonds National de Recherche is supporting this conference here. And this is why we could invite you and that we were able to organize this very stimulating event. So the floor is yours. Thank you very much.
Good afternoon. I don't know how to switch the next slides. Perfect, I will make it a sign. So my name is Asaël Rouby. I'm representing the Fonds National de la Recherche in Luxembourg. I plan to introduce you what the funding agency could, the next slide please, and will do for supporting this kind of conference. But before that, I plan just to introduce you, because most of you are not from Luxembourg, what's happened in Luxembourg. We are a small country. If you could please switch to the next slide. Yeah, perfect. The green. Yes, perfect. So everything is quite new in Luxembourg. The founding agency, Fonds National de la Recherche, set up in 1909, the University of Luxembourg, 2003, and the Max Planck Institute, to give you figures, 2012. So everything is very recent in Luxembourg, but we try to strengthen everything. The landscape of Luxembourg also, we have one university in this big country, is in the middle in Luxembourg, and we have in Esch-Belval, where come later on other stakeholders. But we are just a few, and therefore the Fonds National is very proud to support this kind of international visibility and conference that we could have. We set up in the south of Luxembourg a campus called Belval. We are in this building, this green building, but we try to have a kind of campus where every stakeholder could be there. So it's very impressive. If you have time or come back to Luxembourg, you could also have a look at this was happened at Belval. We are a funding agency, like other funding agencies. We try to support excellence in research. For that, we have the vision that Luxembourg could be and should be a leading knowledge-based society. Therefore, we have in our mission to have world-class excellent research system implemented here. And for that, like a classical funding agency, we have different funding, project funding, person funding to attract person here in Luxembourg. If you are thinking of coming back to Luxembourg, we have this attract consolidator. ERC consolidator is quite similar, or Pell grants to come to Luxembourg. So have it in mind that the FNR also provide money for the PhD grants. You could have collaboration. We have something for innovation, PPP scheme, private-public partnerships, where we also try to support. And what is quite interesting and new for other funding entities in Europe, we have a science and society communication. We spend 3% of our budget just to promote what happened in research over TV, over different emissions. And you have international collaboration, so if you're coming back, flying back in your own country, you might have a bilateral agreement with Luxembourg, with the Fonds National de la Recherche, and could submit together with your funding agency here in Luxembourg a joint project. So have a look at that. The webpage of the FNR is there to just, if you're thinking today the discussion was so fruitful that you could think of submitting a program or research, FNR will support you. Science and Society, just because it's quite particular, go on our webpage. We have interaction with Mr. Science, who try to promote, explain what's happened in science so that the public is supporting you. Because Luxembourg spent more than 300 million per year to this research, so it's an amount of money that we are happy to have this kind of very nice conference. And therefore, I thank you all to be there. I thank Professor Bocates to invite and make such big events, and we are still supporting that kind of event. For further details, you could look at our webpage or annual report. Thanks a lot and enjoy the afternoon.
So, ladies and gentlemen, we move to our third panel with the intriguing title, Internet Disruptor or Facilitator. Or both. And we have two speakers, and they're going to speak for around 20 or 25 minutes each, and we'll follow that with plenty of time, I'm assured, for questions. So, our first speaker, Tobias Lutzi, from the University of Oxford. Tobias has yesterday handed in his doctoral thesis on the private international law as a tool for regulating the internet. I know this because I had the pleasure of supervising the thesis. And Tobias has now taken up a postdoctoral position at the University of Cologne. He will be speaking today with the title, Casting the Net, Has the Court of Justice's Approach to Online Torts Made the Brussels Framework Fit for the Internet Age? Thank you.
Okay, thank you very much. So this clearly being the worst time slot right after lunch, I'm very happy that I can go back to some points that have been made earlier this morning and hopefully to tap into the energy of this very inspired discussion. The Brussels Convention is evidently much older than the internet. If we ignore like the handful of researchers who were working with it in the 60s. But when the convention became a regulation in 2001, the internet was already widely available and actually well on its way to replace most other means of communication. It had even troubled some courts already, although this was mainly in the US. But still, the drafters of the Brussels I regulation decided against making any technology-specific amendments to the very broad and general rules of the instrument. And the same is true for the 2012 recast. So while in other areas the regime has become more and more sophisticated over time, when it came to the internet and the challenges of its borderless nature, the burden of applying broad general rules to it fell entirely upon the shoulders of the judges at the Court of Justice. In this talk, I would like to take a look at how well they have managed to do this with regard to one specific provision, which is Article 7.2. And again, a lot of this goes back to what we discussed earlier today. But before we go there, one disclaimer. In the preparation of this talk, I have been asked why I don't offer a specific solution for the different problems I'm going to address. And personally, I think there would be a very good solution for all of them. And the solution would be not to apply Article 7.2 at all to internet cases. In a perfect world, we would just ignore Article 7.2 for the very reason that there is no place of the harmful event, so we would not worry about Article 7.2 at all. There simply is no harmful event that we can sufficiently localize, and therefore we would ignore it. I suspect that Advocate General Bobeck might have been sympathetic towards that proposition, giving some of his opinions. And actually, others too have invited the Court of Justice to consider to at least partly disregarding Article 7.2 in these cases. But sadly, the court has declined every invitation of that kind. So it may be time to accept that Article 7.2 will remain a very important provision in internet cases and with regard to online torts. So instead, I would like to use the opportunity of this talk to take a look at the emerging framework of the court's interpretation of Article 7.2, at the emerging coherence, but also at the inconsistencies in its approach. So just very quickly, we've already talked about how Article 7.2 is understood traditionally as referring to both the place of the causal event and the place of the damage. And we've already seen how this interpretation, this very wide interpretation, has given rise to some problems whenever there's non-physical damage involved, such as reputational damage or purely financial loss. One of these problems was addressed in the decision in Chevel with regard to defamation in printed newspapers. And there the court clarified that the place of the causal event can be assumed to be the place of establishment of the publisher, while the place of the damage will be understood as every place to which the content in question has been distributed, but with the competence of the courts limited to damage done within their jurisdiction. So this is the mosaic approach, which has ever since played a major role, especially in internet cases, only in internet cases. And in fact, what emerged from this decision is a system of two slightly different regimes that are available depending on the nature of the rights that have been infringed. So we're going to take a look at these two regimes. The first one applies to personality rights, so the ones at issue in Cheville. And there, when it came to the internet, the court confirmed the decision in Cheville and held that there would be jurisdiction at the place of the event giving rise to the damage, as well as at the place of the damage understood again as in Cheville, following the mosaic approach. But the court also admitted that this would be a problem in this case for the claimant, because slicing up jurisdiction into territorial parts would mean that a claimant would often have difficulty to find a forum with full jurisdiction outside the defendant's domicile. And the court found this unsatisfactory. So it also created an additional forum, the center of interests. And I think created is the right word, because it is very hard to say what is the legal basis for this. So in cases of online violations of personality rights, we have these three different grounds for jurisdiction, which may lead to many more individual fora, most of which will be territorially limited, but there will also be a proper forum actoris, as was mentioned earlier. And this regime was earlier this year confirmed in Bolak-Suppleisningen, where the court essentially affirmed it with one important qualification, and that is that the mosaic approach is unavailable for certain remedies. So it can't be used for an injunction to rectify online content, because this is by its nature indivisible and therefore cannot be granted by a court that has only jurisdiction for damage caused in a particular jurisdiction. And we will go back to this point. Meanwhile, the second regime is what applies to all other rights, it seems, where the place of the event giving rise to the damage and the place of the damage are equally available, but where the center of interests is not available. And this can be observed in a number of cases. I even omitted the first one, which may be Wintersteiger, where the court first said center of interests not available for anything but personality rights. But it was then confirmed in a number of other cases. So in these cases, there's these two grounds of jurisdiction. So if we look at this framework, I would say there's something good about it, something bad, and something complicated. Let us start with what is good about it. There certainly is a bit more consistency emerging across the case law. And if one accepts that the individual elements of this approach are correct or even sensible, then certainly the Court of Justice can be lauded for applying them relatively consistently and even for helpfully refining them, as we've seen in Bolak-Suppleisningen. For instance, it is quite firmly established now that for all online torts, the place of the event giving rise to the damage is available, which has also been defined in other cases which are not necessarily linked to the internet. The place of the damage is always available under the mosaic approach. And then there's just one special forum, which is only for a specific type of torts, which are these infringements of personality rights. What I would say is the most problematic feature about this framework is the mosaic approach. Mainly because the threshold for jurisdiction based on it is incredibly low. Essentially, the claimant will be able to seize a court as soon as they have shown that the content they are complaining about has been available in a given country. And by the very nature of online communication, in many cases, it will be available in all of them. So there's virtually no threshold to establish jurisdiction on this basis. And obviously, this offers some potential for abuse. Sorry. It was mentioned earlier, of course, and it's repeatedly mentioned, that this is not a problem because the jurisdiction that follows is limited to a very small slice of the damage. But I think one has to realize that not every claimant is actually interested in adequate compensation for their loss. Least of all in personality rights cases, where even we cannot really agree what is the measure for adequate loss, and it differs quite substantially between the member states. So instead, claimants are often interested in just getting a judgment in their favor, because that carries some degree of redemption. And if that is true, then it is problematic that the mosaic approach can be used to find jurisdiction in up to 28 or soon 27 member states. Also, the mosaic approach raises some difficult questions of fact, because in order to define the degree of their jurisdiction, courts have to establish what part of the damage was caused in their jurisdiction. And if you don't have printed newspaper, copies of which you can count, then this becomes very tricky. Also, I think this really has been discussed at length earlier today. It, in my opinion, too, conflicts quite heavily with the actor sequitur principle and with a number of other principles, such as the sound administration of justice or the proximity principle. So finally, turning to some more subtle points, which may be a bit more hidden. A first point I would like to make is, or discuss, draw attention to, is the limited availability of the Center of Interests Forum, which is only available for personality rights. So it seems clear from the case law that it was introduced to tackle a very specific risk of to which these rights are exposed on the internet. But of course, you would find holders of IP rights who would argue that they are exposed to the exact same risk, and that they too deserve the protection of this additional forum, but they don't get it. Additionally, with the decision in Bolak-Suppleisningen, which has reduced the usefulness of mosaic approach jurisdiction, the gap between the two regimes becomes wider. So the protection of personality rights is even stronger compared to other rights, supposing that the limitation in Bolak-Suppleisningen applies to both sides of this table. Of course, this is not clear, and this is my second point. We don't know yet whether the limitation of Bolak-Suppleisningen actually applies to both sides of this. And why this is not entirely implausible is because the court may have been inclined to hold that the injunction that was sought in Bolak-Suppleisningen could not be granted based on mosaic approach jurisdiction, could be because the court knew that there was a much more useful forum available in these cases anyway. In other cases, this is not available, so one could argue that mosaic approach jurisdiction in turn would not be so limited. I don't make this argument, and I think there's a stronger argument for saying that this jurisdiction really, this jurisprudence applies to the mosaic approach generally, given how it is linked, it seems, to the very concept of territorially limited jurisdiction. But nonetheless, it at this point remains another point of uncertainty. And finally, a third question I would like to raise is the question of which remedies are actually divisible. So for which of these remedies can you use mosaic approach jurisdiction and for which can you not? It is clear that compensatory damage awards can be based on this limited jurisdiction. It is equally clear that injunctions to rectify information on the internet cannot be based on it. The same is probably true for a number of other injunctions, such as to delete content. But what about injunctions not to make content available only in a specific member state? Could that still be based on the mosaic approach? And could a court even find jurisdiction by limiting the remedy to a specific member state? Also, what about other damage awards, such as punitive damages? Can they be sliced up? So what I think these different open questions are a consequence of are two rather fundamental mistakes in the case law of the court. The first one being to apply Article 7.2 at all, even though there is no harmful event in any meaningful sense in most of these cases. And then the second mistake was to address the very specific problem of the protection of personality rights through the creation of an additional forum without any legal basis for it. And all the other smaller problems kind of follow from the court trying to remedy these two decisions. Of course, to properly correct this, it would require a proper revirement de jurisprudence, which would be completely out of character for the Court of Justice. So instead, the next best thing one can hope for is probably just a sensible refinement of this framework. For instance, one should hope that the center of interests as a forum remains at least limited to a small number of cases, because, as we said, it goes very much against some fundamental principles of the Brussels framework. Similarly, one would hope that the qualification in Bollag-Subneisningen applies to the entire mosaic approach. So finally, where does all of this leave us in terms of an overall assessment? Well, while I personally don't find this ideal, it is surely not all bad either. So one thing that is surely rather good about it is that, except for the center of interest criterion, most of this is more or less technology neutral, because it relies on a combination of actions and effects-based thinking. So it can probably be applied as technology advances. For instance, with the emergence of increasingly pervasive online platforms, what we're seeing are more and more cases that do not just involve two litigants, but also a third party, a platform host, which may actually lead to a certain concentration of jurisdiction in some cases, which could be based maybe on the place of causal event as the stronger connecting factor. At the same time, other technologies such as blockchain lead to a certain decentralization of jurisdiction, but equally one could see how many of these problems can be addressed through this framework, maybe with a stronger focus in this particular regard on the mosaic approach. So I think what one can hope for is that the Court of Justice will receive further opportunities to refine this framework. I think this is beyond doubt that this will happen, and that the court does, in fact, refine it in awareness of the need for clear criteria and a coherent legal framework. Thank you.
So our second speaker this afternoon, Alina Ontanu, is an assistant professor at Erasmus University in Rotterdam. Her research focuses on civil procedural law, in particular in its interactions with consumer law and private international law. And she's speaking to us on the topic of encoding justice, the quest for facilitating access to justice by e-handling of cross-border litigation. Thank you.
Thank you. Thank you for this opportunity to take a different view on the challenges that internet and technology can bring to civil justice and private international law. Certainly, it can be a vehicle for procedural justice, facilitating access to justice, but at the same time, it can be a disruptor, bringing barriers in not only for low literate parties, but also in terms of technology used and complexities. Developments have been gradual in the area of procedural law and technology, and it kind of started up with using technology for basic courts tasks, facilitating the work of judges and registrars. But further steps have been taken in order to bring more information to the parties, and also aiming to bring a full online handling of procedures at national level, which is in certain countries more advanced, but also in cross-border procedures. At the moment, there are various aspects that technology addresses in cross-border litigation, and this is providing information to interested parties, but also to practitioners that need to litigate in a different member state. Does make electronic available standard forms for procedures that do rely on standard forms. Provides access to national registers and tries to facilitate access to data. Okay. And hopefully at a certain point we will manage to have easy access to electronic cross-border claims, not only for practitioner, which is the case now for piloted courts, but also for general users. We're not yet there, but maybe in the future. And for opening up access to cross-border procedure in an electronic format, the European Uniform Procedures have been part of this development, have been used as a starting ground. And I mean here the European Order for Payment and the European Small Claims Procedures. There were plans to try to pilot also the European Account Preservation Order in electronic format, but this has not happened yet, and I'm part of a project that seeks to do that, but decisions have been made to focus on service of documents first, and trying to bring that in an electronic format between member states. Well, in trying to set up a framework, a European framework for infrastructure that can support such use of technology and deploy it in European e-justice, we have to base ourselves practically on national infrastructure. And here we don't have a level playing field yet. Each country is at different stages of development. Some do use electronic procedures in their national law, but these are hardly open to cross-border parties because of the complexities and legal requirements that parties have to comply with. So, yes, technology can support cross-border procedures, but there are still aspects and complexities that not always are upfront visible to designers of these networks, but also to practitioners that are involved. This is also okay. Law and technology themselves are two different regulative regimes, and they have their imperatives that have to be brought together and assembled in a way that they can function together, and interconnecting them in a way that legal validity is maintained in cross-border procedures. So this is why I'm trying to look at these elements of complexity from a procedural point of view and see what are the aspects that should always be considered when designing this kind of procedures. Because sooner or later, I think algorithms and different developments would also be added to this endeavor of having networks that support this kind of connection between member states. And of course, when we look at the European uniform procedures, but also at technology and what was the aim of bringing technology in, was the idea of facilitating access in cross-border claims, simplifying to a certain extent for parties to make use of technology support to file their claims, making it faster and less costly. But are we achieving this at this point? Access to justice remains a key point in the discussion. And I personally think that when we look at procedural rules and the developments, that we seek to provide clearer information for a supporting party to access court procedures or out-of-court procedures, diminish cost and so on. We look for simplicity, and we set standards. And these standards should not only abide by procedural aspects, organizational rules, but should also be taken on for technology. They should comply, technology use should comply with the same requirements. Otherwise, complexity would make it very difficult, raise barriers for ordinary parties, but also for practitioners that cannot use that mechanisms. So this is why I see IT input in procedural law from two points: facilitating and aiming to facilitate, but also creating barriers. And I think we have to be aware of the possible barriers in order to make use of it in terms of facilitating. And address both, or I think imperatives from three different parts: the technology, the procedural law, and the organizational level. And of course, I do not exclude human assistance. I think human assistance should always remain available. Also, when technology is quite at an advanced level and can support procedural claims, because there is also a possibility to that technology rigidity makes it impossible actually to carry out the procedure, and this is not always obvious from the start. In the European Uniform Procedure, the European Order for Payment, and the European Small Claims Procedure, when piloted in cross-border claims between member states, certain procedural aspects became visible only when tried with actual cases. It was not expected that, for example, service or signature or identity of parties would be an aspect of complexity, because when you personally file your claim to the court or sign a document that you file with the court, it's a very simple action. But technology makes it quite complex, also because of the identification requirements, making sure that what is a system recognized in a state, in a member state, is considered valid in a different country. I would want to ask you whether you're all familiar with the European uniform procedures, or should I briefly address them? Maybe they're quite niche for some of us. Okay. So the idea behind these procedures is to create alternatives to national instruments. They are mainly written procedures in order to facilitate and speed up and diminish cost in cross-border litigation, and they address specific issues that have to do with recovery of debts. Two of them, the European Order for Payment and the European Small Claims Procedure, are single-sided procedures, so the court issues the decision based on the submission of the claimant, while the European Small Claims Procedure is an adversarial procedure. All three of them provide a uniform procedural format, but still rely to a significant extent on national procedural rules for their application, so they are open to national context differences. Representation by lawyer is not mandatory, so parties are supposed to be able to file the claims on their own. And the decision issued is automatically enforceable. All three procedures encourage the use of ICT for certain procedural steps, and they're all part of European initiatives to provide access to either information or their filing online. When it comes to European initiatives to digital justice related to these procedures, the most important and the ones at the moment that are being developed is the European Justice Portal, that at the first phase kind of brought together information that was available on different websites with regard to not only the European uniform procedures, but also other private international law instruments. And now the aim is to kind of open it up, making it a one-stop shop for procedural justice in cross-border situation, and expanding its functionalities to kind of be an entrance point. The other is the is the e-codex project. That is the initiative, the European initiative that's trying to set a layer that allows cross-border exchange of judicial data and access to cross-border e-justice services. So kind of creating the infrastructure to connect all the national systems in place for such purposes. And we are now in the second phase on trying to bring its long-term sustainability and opening up to general users, not only to professionals and not only in piloting court or between piloting organization. So kind of bringing it up and in the future aiming to connect the two under the umbrella of the e-justice portal, which has not yet happened. It has been postponed for quite a long time, and this is maybe due to also a number of aspects that need to be addressed first, which lead to complexities. And these complexities are based on what I was also mentioning earlier, that we don't have similar domestic system deploying e-justice solution, and not similar when the architecture is in place, not similar solutions. So each national system is different and has been developed differently. And that poses a problem of interoperability and transmitting of information. So all sounds nice to bring everything under the same umbrella, but there are various sources of complexities that have to be dealt with, and they're not always visible up front. And some of the sources of complexities that I have identified looking at the European uniform procedures and having conducted in-depth research for my PhD on the European uniform procedures, especially the European Order for Payment and the European Small Claims Procedure, I do see that interacting of technology and procedure requirements does lead to difficulties because of their two different regimes. Then there's the national technology and organizational infrastructure, the interplay between national and European rules. We might think at first that the European uniform procedures providing a uniform framework may let's say, lower down the complexity, but this is brought up again by the differences in national procedural rules, which are part of our richness and procedural history, but we have to find ways to deal with. Language and legal semantics. And here it's I mean, not only different languages, but also different meanings to the terminology that we use. And also a very important aspect for such systems is reaching the critical level of knowledge for the people that develop it and the people that are supposed to use it, not only professionals, but also lay users, if we open this system also to lay users. And knowledge, because sometimes we invest a lot in such infrastructures, but when procedures are not sufficiently known, then we cannot expect that they will be very much used or easily discovered. May I ask how much time I still have? Okay, thank you. So now focusing on each of these complexities, the interrelating of technology and procedural requirements. As I was mentioning before, both of them have their own imperatives, and they're kind of trying to rule each other, and one going on top of the other. And this has to be balanced in order to obtain the desired results and have valid actions in terms of legal requirements. But technology might shape or turn procedural law in a way that it can deal with it. So in designing procedural cross-border procedures that are handled electronically, maybe for the future we could consider already designing procedures that are posing less complexity in terms of digital handling, because at the moment the way we work with it is the design of paper-based procedure, replicating it in a digital environment, which brings quite a lot of complexity. And then we have to rely on certain circle of trust, mutually recognizing certain technology, but also procedural rules having the same value, although they might differ nationally. And have some common standards that we can agree upon in order to maintain this complexity manageable. Of course, there is a risk of oversimplifying and impairing on the guarantees, but there is a fine balance there. I'll move on to national technical and organizational infrastructure. What was the solution that eCodex chose to experiment is building blocks, so not modifying national systems, but building on their what is already there and finding way to have interoperability between them and having the connectors that would translate legal valid procedural steps across border. The interplay between national and European rules, of course, with the European uniform procedures, we have a certain level of standardization. But as national rules jump in, there are some limitations to what is standardized, and we have to deal with that diversity. And that makes it quite complicated sometimes at procedural level to find, at technological level, to find the solutions that would support all this complexity in a simple, friendly procedure for a party that is neither technician nor a legal practitioner. For the language and legal semantics, I think this can at times be quite confusing also because certain terminology used by the regulations does not find an immediate equivalent in the national procedural rules, or they might use the same terminology for both instruments. So then there is a tendency to use the national rule as, or apply the procedural European uniform procedure in a way that is in line with the national known instrument. So here there are quite some aspects that also at technological level there will be necessary to develop such systems and such procedure, not only from a technical point of view, but together with national practitioners or experts that have a clear understanding or an in-depth understanding, better said, about the procedural instruments that we seek to digitalize. When we look at the critical level of knowledge and use, we can complexity can be black boxed and sealed, but then we still have to maybe have a good understanding or a good grasp of the procedures itself, and them having them used extensively at national level before diving into electronic handling of such procedures. for the European Uniform Procedure, is still a modest number of users, so that I think might not bring the electronic format to its full potential. And maybe here there is the possibility of opening up this system to different procedural instruments, such as a service of documents or communication between judicial authorities and enforcement authorities or practitioners. Well, before, maybe before, I cannot, okay. Okay. Before actually looking at fully achieving digital procedures, there are other aspects that can help in this digital handling. And also maybe make standardization a bit more flexible and interactive, and when developing this procedure and using them, have in mind that the digital procedure is quite different in structure as the paper one. So in the long term, maybe different approaches to this architecture could be thought of. And technology is not a solution for everything in facilitating access to justice in cross-border. It's just one of the elements that can contribute to this. So I leave it here.
So we have plenty of time for questions and comments. Just by way of introductory remarks, it seems to me that if you listen to the two presentations, they just appear completely different. They appear to have nothing to do with one another, apart from the fact that they deal with technology. One deals with the role of technology in generating legal disputes, and how we seek to deal with that. The other deals with the role or the potential role of legal technology in resolving disputes. What it seems to me they have in common is that they both look and focus at the potential of technology. In the case of Tobias's presentation, it's the fact that it's so difficult to harness or limit technology that makes it such an important development in terms of its potential to create legal disputes, and we have to think very hard about how we deal with that. For Elena's presentation, nobody would doubt that technology has a great potential as a tool for resolving disputes, but what we have to consider is it's not really the doctrinal aspects, but the technological aspects of how we harness technology and how we use it to achieve that potential. So I'll open it to the floor. If you put your hand up, if you would introduce yourself very briefly before you ask a question or make a comment, and I'd ask you keep the questions and comments reasonably brief so we can give the panelists a chance to respond. And I will take one or two and then turn it over. So first, yes, please.
Thank you very much. My remark goes to Mr. Lutzi. Departing from your framework of analysis, you classified the mosaic approach as bad. I would agree, and I would say it's bad and ugly at the same time. What's the rationale behind this concept? It underlines well, of course, it gives some opportunity for forum shopping, but most people say, well, no problem. It underlines the importance of the defendant's domicile as a general rule, because no reasonable plaintiff would ever run the risk or invest the money for 26 lawsuits at the same time. 26 means 28 minus the defendant's domicile minus the UK. But is this really true? I used to give my students a hypothetical case. You have a critical journalist, and he's writing articles, either on the internet or in print media. And one of his favorite targets is an international business entity. And they want to get rid of him. They try to silence him just by starting 26 parallel proceedings. In this case, Article 29 is of no help at all, because, well, there are 26 different causes of action. And even Article 30 doesn't help, because in any case, he has the burden to defend in 26 different fora. So I think it's high time to abolish this music approach altogether, get rid of it. And because it never helped the weak, but it's a very powerful tool in the hand of the already powerful party. Thank you.
If I can just remind those who contribute to identify themselves at the beginning. We'll take the two there. We'll take those, and then we'll come to the panelists. So, penultimate row.
My point was very similar to Professor Howe's. Sorry, Alex Layton, I'm a barrister, I think, but I introduced myself before lunch. My point is very similar to Professor Howe's, but it is an additional ugly point that arises from the mosaic principle, which is the preclusive or res judicata effect of one set of decisions in other decisions, even if they are postponed by operation of Article 30. Gotauer makes fairly plain that that part of a reasoning that leads to the dispositive in the judgment under the doctrine of mutual trust has to have effect in other member states. So there may be arguments about the limits of that principle, but I would suggest that it's an additional reason why the mosaic principle is best abolished.
Thank you, Geert van Kalster. A question for Alina, one for Tobias. Tobias, first, we all like to hate the locus damni implications, and like many of the advocate generals, I think plenty of us wanted abolished. But then, even locus delicti commissi in an internet context, I find is becoming difficult to enforce. A little bit like that sort of a scenario. What if you have a media outlet with an editorial team spread out in a variety of places, and putting all sorts of stuff on a blog from those places, a media outlet that is moreover owned by a financial conglomerate that sits elsewhere, the editorial team has some sort of a meeting place somewhere else. How do we define locus delicti commissi in an internet age over and above locus damni? And Alina, a very, I suppose, practical question, potentially triggered by a practice concern. Would you say in the current context of these technological advances and in some member states having automated decision-making by tribunals, would you say that an algorithm-driven tribunal could qualify as a court under the European private international law rules?
Would you like to start with that one, and then we'll move on to the Article 7.2 points?
I know that there are some countries that for order for payments, the national order for payments, and I think also for the European instrument, the European order for payment, because it's only based on the standard form, they would grant it in a more or less automatic manner, and it is for the defendant to oppose it, and that is fine. It works in some systems. If we look at algorithm-driven tribunals and we match it to this situation, I think it's not much different. If we look at the problematics that algorithms and the problem of biases of algorithm pose, I would not leave it at least to, let's say, more complex or the ordinary procedures. I would not be comfortable to leave it to algorithms alone. I think there should be a judge check on the decision. Of course, there are different discussions related to data mining and what can be brought up if the algorithms give the judge a specific suggestion for the solution. Should the judge take that, or would it be more difficult to have a different perspective? But I think with algorithms, we are not there yet to have it so refined that an algorithm could grasp all the, let's say, nuances of the case. So I think we cannot leave everything to algorithm, and I think human intervention is still necessary and will remain necessary for quite some time to come.
Yeah, I'd add, I'm not sure I'd put the question in terms of is it a court. The question is it a judgment? The solo Klein-Morturen case is the place I think I would start in thinking about those issues, but it's a really interesting question. So Article 7.2.
Well, thanks first of all to everyone for agreeing with me with regard to the mosaic approach. And so I think the potential for abuse is obvious. It's a bit hard to tell how often it is actually abused in that sense. I mean, there's not many cases of that kind. Then again, some of these high-profile UK cases before the UK Defamation Act, they were based on a very similar reasoning by the English courts, which allowed claimants essentially from all over the world to establish jurisdiction in the English courts. And they were used more to get a judgment from the English courts. Some of them openly acknowledged that what they were interested in was a judgment by an English court, and that's it. They were not interested in getting compensation for their damage. So it didn't matter that the claim was then only for that part of the publication that was distributed in England, because even though it was very small, it gave them the opportunity to seize the English courts. I think the potential for abuse was even larger before February, when the BOLAG Subleistungen decision was made, because using it to get an injunction, I think, was the worst in that sense, and at least that danger does no longer exist. But nonetheless, there's no good justification for it. There's lots of problems. And one very structural problem, obviously, is that it creates 28 courses of action, which can then not really be properly administered through the lease pendants provisions we have, because all of these are treated as different proceedings. Regarding the place of the causal event, I would like to disagree that it's always as complicated. So it is true that in many cases it is hard to identify it, but at least the Court of Justice has moved a bit into the direction of a center of gravity approach. Already in Wintersteiger, it was argued that one has to identify the relevant decision that was made rather than any other step in the process of publishing. And in Nintendo recent decision, that also hinted towards just looking at what is the most relevant action that was taken. And I think that can be helpful, given that otherwise one is left with jurisdiction at the defendant's domicile, but domicile is not necessarily the same as habitual residence. And in these cases where a defendant is domiciled in one place, but quite clearly habitually resident in another, the place of the causal event allows to bring an action with the court having full jurisdiction in this place. So I think there is some role for it, even though there may be other cases in which it's just too complicated to properly establish it.
Okay, so we've got one just there, and we'll have one here.
Thank you very much. My name is Björn Laukemann from Max Planck Institute. I have a question for Tobias Lutzi. You mentioned that was an interesting aspect, the potential of Article 7.2 to concentrate proceedings in a third-party setting, and you mentioned explicitly platforms. If we take the example, a typical example of online platforms, we have three parties, an IP right holder that gives notice to a platform, let's say eBay, that there's some allegedly illegal content and that content has to be removed, and upon that notice, the platform removes the illegal content. So we have a three-party setting. In what way do you see there a potential for concentrating lawsuits? Could you precise maybe your idea? Thank you.
Etienne Farnoux, a question for Tobias. And jumping on this discussion on the mosaic principle, wouldn't you agree that maybe in Beleid-Suppleisningen, it seems that the court is sort of moving or hinting in the direction that maybe the center of the interest of the victim would actually be the most relevant place for the loss, for the location of the loss, in a way sort of bypassing or hinting that maybe it could bypass the actual location of the loss under Fiona Civil.
So we'll take those two, I think.
Yeah. So with regard to that point, I mean, yes, this is evident in the court's reasoning as the basis for the center of interests approach, and it is more clearly articulated now that the court sees the center of interest as just one place of the damage and the most relevant at that, but it does not abolish the significance of any other place of the damage if the claimant wishes to rely on these, which is, I mean, it was such a great opportunity to actually do away with the mosaic approach, right? And they came so close and then still didn't seize it. And the Advocate General's opinion, I think, is excellent and should just have been followed. So we are still stuck with these different grounds for jurisdiction, which I think goes back to what you said earlier in the morning. It is all about protecting the victim more than anything else, and taking away any ground for jurisdiction from the victim seems inconceivable to the court. So with regard to the platform point, I think at this point, in many cases, very practically speaking, what these platform settings offer are, first of all, a very easily identifiable defendant, which is the platform host. So if you think your IP rights have been infringed, instead of seizing state courts, you simply go to Facebook and ask them to remove the content you think is infringing. That makes everything much easier, not just the jurisdictional issue. Of course, then the other party has the problem of wanting the content to be put back online, but they can all litigate with the platform host, and that's what they actually do. So that's just a very practical point, which I think solves some of these problems. It doesn't really solve the problem of the abstract framework, because if you wanted to sue Facebook over what they do with your content, you could probably still rely on all these different fora. It's much easier, and you know where Facebook is. And they also have access to information that may be useful for you. So for instance, you could ask Facebook to release data as to where the other party acted, or even who the other party is, which wasn't necessarily available when the internet first came around, when everyone was hidden behind anonymous websites. So these are more like practical points rather than actually changing the legal framework.
Just to add something on the first point, it seems pretty clear from eDate that what the court's doing is creating a weaker party protection in disguise. But what's baffling, there are two things that are baffling, that it then rolls on with it in Beleid-Suppleisningen, where you think there's no inequality of power between the parties, and so it then takes a general shape. But in other concepts, and Kainz and Pantherwerke, the product liability case is the one I have in mind, they deny that Article 7.2 can ever be used to protect weaker parties. So eDate is one of the most problematic decisions, for me, one of the most problematic decisions the court's ever delivered on the Brussels I regime. But just a bit more honesty as to the reasoning would be nice, and we could then work out what the limits of the principle should be. We still got some time for more questions and discussions. So would anybody else like to contribute? Professor Hess.
I would like to start with a remark and a question for Alina. We are already now experiencing that IT is changing lawmaking, and I was struck by the bad phrasing of the consumer dispute, consumer ADR directive. We have some articles which are describing forms, others are providing for principles and rights and competences, and you can only understand those instruments when you look at the forms or at the web pages they shall establish. And I have the impression that if one looks at the European Payment Order regulation, we are in the same setting. This instrument has already been conceived from a perspective of the forms to be applied. The same also applies to the regulation on the bank accounts. Again, we have very different provisions, and the worst thing is something which you find in German textbooks, where you only have the texts of the instruments, but not the forms in the textbook, and you are really lost because you don't have the whole picture. So here's something changing. Do you see a general trend? Do you have some ideas how to make it better? Also the lawmaking, to improve the lawmaking? And Mr. Lutzi, I have one question for you. Isn't there a huge difference also between injunctive relief and damages when it comes to Article 7, number 2? Maybe damages are much easier than cross-border injunctions. We have not much reflected about cross-border injunctions. We had some cases where the court was really reluctant in granting them. Land Oberösterreich is one example for that. And when it comes to local injunctions, and now I can go to the personality rights, I would say these might be less problematic then, because it might be limited. My idea is they cannot be enforced cross-border. Yeah? The possibility of geo-blocking has not much been addressed in front of the court, and this might be a technical vehicle to limit also the territorial reach of judgments. So I would like to know a little bit more whether you see both constellations in the same way or whether you see some differences. I haven't made my mind finally yet, but I think there is room for distinguishing.
Elena.
Yes. I think when looking at the forms, at some point, I think for the small claims procedure, it was a bit more obvious or stated that they have been developed with the user in mind. But when I look at them and the provisions, I have the impression that they have been developed with the procedural rules in mind, so to comply with procedural rules that and possible technology use. So maybe in this kind of forms that can be automatically translated in other languages, but certainly from a user perspective, I don't see them user-friendly, and I think the exercise has not been successful so far. And here I think of maybe it would be better for users to kind of come up with flexible format that can be adjusted. So when you have so many different approaches, either with codes or with ticking boxes, it's difficult, especially for a first-time user. Once you kind of get used to them and know how to orientate in working with them, it becomes easier, but certainly it is a learning process, and it's not obvious up front. And the explanations that are available are not always sufficiently detailed, sufficiently helpful. The wizards that are available are the same. So here I think we should maybe European-wise think of a more common frame that can be adapted per instrument. And that might also be helpful when thinking to digitally filing this kind of claims that are based or requirements or certifications, and also feeding in information, so that would be recognized and automatically taken from one form to the other. And at the moment, I don't see common ground between them, at least in their substantial part. And maybe when looking at the European uniform procedures and what happens in practice, and I have this, and now in mind the European Order for Payment, maybe this is also why at national level judges feel the need of issuing the form, the European Order for Payment, together with a national decision that complies kind of with the requirements of the national law for what is a judgment in certain countries. I think these different formats that are not adaptable easily create all these additional complexities that we kind of try to deal with in practice, but it's no optimal solution yet.
It seems to me that there must be a potential, I don't know whether it's being done already, just to harness the unlimited number of people who are willing to spend their time creating solutions to practical problems that exist. You just provide them with the problem and maybe with an initial software solution to it, and you tell them to improve it for you. And somebody one tends to find will do that. So it's an ongoing process. So we'll move again to Tobias.
Thanks. That's of course a very interesting and important question. So far the discussion has been around two kinds of remedies. First, damages, which were always assumed to be very easily very easy to slice up into these territorial parts, and then injunctions, which for a long time were not discussed, at least by the court, and which have now been considered impossible to slice up, at least certain kinds of injunctions. So for damages, I think this always was a bit too simplistic. First, because it's not that easy to split up even compensatory damages. And second, because, as I said, compensation is not the only reason why a party seeks damages. And as long as you accept that, it is possible to kind of do this mosaic approach, to take this approach, but you have to be aware that it's not only about compensation. The injunctions you mentioned, which may be territorially limited, a court just ordering a party not to make content available in one member state. I think based on... Yeah, exactly. And based on Bullock sublicensing, I think it may be possible to base such an award on the mosaic approach. One has to accept then that this is never perfect. And it would then depend a bit on the substance of the order, and the stricter a court tries to be, the harder it would be to actually implement this without having cross-border effects, right? Because it is rather easy to use geo-blocking technology to block most users out of certain online content just based on IP addresses. But as soon as you also require them to stop users from using, say, VPN clients, it becomes quite messy because there's many ways around geo-blocking technology. But as a solution for the majority of internet users, this may work, and then I think it's actually kind of really in the middle between damage awards and injunctions, which cannot be split up.
What's your take on the Court of Justice in the concurrence case, an unfair competition case or something approaching it, appeared to apply the same principle to an injunction without blinking? Is that just because they overlooked the significance of what they were doing, or because they thought that IP and unfair competition cases were just different from personality rights cases?
Yeah, I really don't know. I think I may not have mentioned it, but concurrence actually was decided while Bolag's sublicensing was already pending, but before the award was made. And the injunction there seemed to be at least not to make products available in France. But the court simply ignored whether or not this was an injunction, just a territorially limited one, or whether it was a broader one. It was just completely disregarded that this would be an issue. So,
but it was targeted at an internet selling network. So if you don't make products available in France, as I understand, you don't really make them available anywhere else. It's very hard, at least technologically, to just shut down the French part of that particular operation. So we have time for one or two more questions, and we have two. So we'll take those and then we'll bring the session to a conclusion.
Hi, thank you. I'm Eva Storsgrupp from the University of Uppsala. Alina, as you know, I have an interest in digitalization of justice, and also one of my pet projects the recent years has been this issue of service of documents. And my question is, because you mentioned you're working on a project of a service and digitalization, can you maybe tell us a bit more about it, and what are the principles behind that? Because I think it's very interesting how also the practical realities of our use of technology and the service rules don't really at all match. It's only Denmark, of all the countries in the European Union, that say that all citizens should be available for electronic service. So all citizens have an electronic portal, are obliged to do so unless they're impaired. But basically everybody has an obligation to be on an electronic portal, be electronically available for the state to serve them at any time. And that's the only country in the European Union who does that. But I think we're moving fast towards maybe people being prepared to do that. I don't know, some people are not. But it's of course a question of relationship between the state and the citizen. Do you think that you should be able to be served while you're at the gym or at home at the middle of the night, or at a ping of your mobile phone? But the Danish do this, and is that issue involved in that project, that we would go so far as to all be obliged to be able for electronic service? Thank you. Maybe that people are looking scared now around me, but that's the way they do it in Denmark.
Thank you very much.
We'll just take the last question. 2 rows forward. Just here.
Marcel Karl, Research Fellow at the Max Planck Institute. I have observed your discussion about algorithms and, the law in texts, and Professor Hess's comment about it's difficult to understand the text of the new regulations if you don't look at the forms. Just a thought that came to my mind, which is maybe we could consider starting to make laws just in algorithms. And what I'm thinking about is the flight compensation regulation, which I think is in practice basically just an algorithm that we apply. The courts might not have noticed that, but that's what the parties do.
I'm not sure I understood the question.
Should we change the way we make laws so as to use algorithms? We'll take a note. I think they were both on. So take them in whichever order you want.
I'll start with the first one. Well, actually, this doesn't want to reach. I don't know whether that will be the next step. So to make electronic service valid anyway, but what it seeks to understand, and it's a bit going back to my research. We looked because I was looking at European Order for Payment, and service for European uniform procedures is part of the framework. And then, of course, you think you have some uniform solution. So it's what the regulation prescribes in Article 13 or 14. But actually, when you look in practice, what happens at national level, there's a diversity of what can be applied. So starting from there was a follow-up on the e-codex because it was prolonged each time. Under the pro-codex, so a follow-up of it, there was interest in knowing what practitioners would want to see developed electronically or have applications to kind of file electronically. And service of documents, the regulation on service of documents was one of the instruments that was, let's say, more used or more interest for that. And now with the maintenance, the follow-up of e-codex, practically, we are interested to discover what are the national particularities in service of documents and what are the steps that are taken at national level. So physically, what you do to have your documents served in a different countries in order to be able to, so by understanding all these particularities, to build up solutions that can be electronically handled and at the same time comply with the requirements of practice, because sometimes it's a matter of practice. It's not mentioned in the law itself, but it's a matter of practice and how either courts that are involved in the service of bailiffs or other authorities work in order to be able to build electronic solutions that can sustain electronic transmission of documents in service, but also maybe managing to propose electronic service of documents. But then I think for that purpose, it depends also on what under the national law would be considered a valid service. So if in Denmark that is allowed, that infrastructure could allow that kind of service, in other countries it might be more limited, because we have some European instrument, but that does not harmonize national law. So that is what is happening now with that.
Quick comment on the other one?
On the algorithm. Yeah, I think sometimes we don't think that it's algorithm driven, the text, or it can be easily put in an algorithm, and certainly sometimes it can be the process that goes behind makes it look so simple that we actually do not see whether there is a problem with the way we apply the text. I don't know whether we aim to kind of go from the algorithm and develop the law from the algorithm, but I think until now it was the other way around, kind of trying to come up with situations that would facilitate the application of the legal text. Then, yeah.
Thank you. So it illustrates the potential of the internet and in technology generally to surprise and to delight and sometimes to shock. But can we thank our two speakers in the normal way?